what was lacking from the evidence before the court, and what appears to be lacking the attention of the judge, is whether there's some cogent scientific basis for making the distinctions she did. There has to be some data from some reliable source focused on the specific activities at issue. And there simply isn't any. There's Dr. Henry's stated reasons to the public as to why she's doing what she's doing, but that's not, quote, cogent and persuasive evidence in support of the restrictions. That has to be produced by the Crown in a case like this, and it simply wasn't.
Big win for freedoms, but also a big loss. It is officially legal to protest during COVID-19 in British Columbia, but the same cannot be said for your right to religious expression. Drea Humphrey here with Rebel News, and many of you know that I've been reporting very closely on the petition that was brought forward by the Justice Center for Constitutional Freedoms. It was over the matter of freedom of religion and the right to peacefully protest and assembly during COVID-19. Now, you may have heard that Justice Hinkson, who was to rule on the matter, ruled that you can protest in BC. Already, we've seen in Vancouver that the Vancouver Police Department has done an excellent job at balancing Canadians' rights alongside with how they use their discretion when it comes to enforcing public health orders. But across BC, we've seen many cases of infringement on peaceful protesters, like David Lindsay here from Kelowna, who's received almost $10,000 in fines. He's one of our Fight the Fines cases where you donate there to help hundreds of Canadians find free legal counsel from us. We hook them up with champion lawyers who fight those fines so that they can keep on fighting for freedoms. Another example is here, Pastor David Marks. Now, he received a fine not because his church was wide open. He received a fine for allegedly having 1 to 2 more people than the allowed amount during, get this, during doing an online service so that the rest of your congregation can stay home. He's another one of our Fight the Fines cases. Now, you can go there to help us out at fightthefines.com, but today I share with you an exclusive sit-down, a candid interview with Paul Jaffe. I met him down in North Vancouver where he gave us the ins and the outs of his take on Justice Hinkson's ruling over the churches and the right to peacefully protest here in BC. I'm here with Paul Jaffe, the lawyer who was at the front line of, I would say, one of the biggest cases in BC history, in my opinion. Certainly one of the craziest. And how was Justice Hinkson going to rule? We've been waiting on pins and needles to see if in British Columbia the matters that were brought forward about freedom of religion as well as the right to peacefully protest how would it be ruled on today? So, can you briefly tell us where we're at? Let's go ahead and start with the good news.
The good news is that one part of our case was successful. That was asserting the rights of Alain Baudouin, a fellow up in Dawson Creek, to conduct outdoor political protests, which had been reined in by the police up there, and he was given tickets, and so a big part of our case, to some degree overshadowed by the religious aspects, but a big part of our case was freedom of speech and freedom of peaceful assembly. And so the court has recognized that the infringements on those fundamental freedoms were unjustified, and so outdoor protests are legal now. Yeah, that's great news.
In BC?
In BC, yes, that's correct. Yeah, just in BC, and whether it has any spillover effect elsewhere in Canada, I'm not sure at this point, but we're very happy with that. With respect to the religious...
Can I ask one question about
Sure.
that first?
Yeah.
So what happens then, my understanding is that, and again, this is with the JCCF as well, that the client also was fined. So what happens to those fines?
Well, the judgment of yesterday doesn't directly and immediately dispose of those, but Mr. Baudouin will simply if the Crown doesn't do it itself, Mr. Baudouin will provide the judgment to the court to show that the basis upon which the tickets were issued has now been set aside. So it won't be any problem for him.
Okay, so now, why don't you tell us what happened for the church? Am I going to be a criminal for going to church?
Well, we were very surprised and disappointed by the judgment with respect to the churches. A victory to some degree in the fact that the court recognized some very clear infringements of the religious freedoms and peaceful assembly rights, and but held that Dr. Henry had established a reasonable basis for her the orders, and dismissed the relief that we sought, which we were very surprised about. His reasoning on that turned very much on characterizing the nature of the enactment at issue, without trying to bog down on legal technicalities. There's basically two kinds of laws in this country. There are the ones that are legislated. They're tabled a couple times. They go off to committee. It's all done in a legislative process where there's transparency and there's democratic accountability. Those are what are called primary legislation, statutes. And then there's subordinate legislation. So many of the laws in Canada come through delegated powers. And so Dr. Bonnie Henry is a delegated power. She can exercise her discretion. She's appointed by the Health Minister under the Public Health Act. And what she does is create subordinate legislation. The judge characterized the orders here properly as subordinate legislation, but then applied a certain test to them, treating them as analogous to administrative tribunals which oversee adjudicative disputes. We argued that the health orders are in the nature of laws of general application, and on that basis the government has to be held accountable on a very onerous test under Section 1 of the Charter. Section 1 of the Charter says limits on constitutional freedoms have to be shown as a reasonable limit prescribed by law and demonstrably justified in a free and democratic society. And under Section 1, governments, for laws of general application, have to produce what's called cogent and persuasive evidence to support the infringement at issue. In the present case, the judge applied a lower test to the Crown, saying as long as he can't find that Dr. Henry's discretion was exercised unreasonably, whether he agrees or not with Dr. Henry's decision-making, he can't set it aside. So he gave the Crown a much lower test to meet to uphold the orders. And to me, one of the most troubling things about that is that it allows for governments to infringe constitutional rights through subordinate legislation, through unelected people, in a process that has no transparency, and if this judgment stands, is essentially incentive for governments to do business that way when rights might be infringed. They don't have as tough a test to meet as they do with primary legislation. So to me, that's a very troubling message emanating from this judgment, as well of course, as the direct impact on my clients, who are now conflicted between the moral and spiritual imperative of this deeply held religious belief and trying to comply with the laws of the Crown. And this is putting them in a very, very difficult conflict. And while the judgment only came down yesterday, we'll see where this thing goes, but very unfortunate.
Absolutely. Now, you said if this stands, I'm going to go back to that in just a second, but I want you to help me make some sense of something that I'm confused about, if you can. Why couldn't the fundamental freedom of religious expression be honored, and so that maybe congregants can go outside in whatever number and be free to worship just the same as the protesters are when they have a message to spread?
You ask a very good question. should restrictions on gatherings be imposed or not imposed based on the subject of discussion? There is, of course, no common sense whatsoever for that proposition, nor, of course, any medical evidence. It's arbitrary and discriminatory to treat religious gatherings anything differently from secular gatherings. And that's a point which unfortunately didn't get addressed in the judgment. We have 60 pages of very careful and helpful reasoning on certain concepts, but throughout that judgment there doesn't appear to be any attention on the issue which we raised. We weren't contesting whether Bonnie Henry had a reasonable basis to impose the broad orders that she did. We know that the data indicated an increase in infection rates and a possible need for the provincial health officer to take steps. We weren't challenging that, but much of the judgment seems to be suggesting that that was the issue. But that wasn't the issue at all. The issue was the differential treatment between gatherings of people. And Dr. Henry herself said, just before imposing these orders that are at issue, she said that when these safety protocols are adhered to, social distancing, contact tracing, these kinds of things like the churches were all doing, she says you can conduct these gatherings safely, and there is she says we have seen no infection risks when gatherings are conducted in that manner. Yet within a couple of weeks of that statement, boom, down it comes on the churches. So, and that's the distinction which we tried to put squarely before the court, but which the judgment yesterday didn't address.
And it's definitely something that still has to be addressed. I was in IKEA the other day, and I kid you not, it was a zoo. People were going every which way. I didn't see any evidence of there being a cap on how many people can be there. You have people sitting on one office chair, then the next, and then repeat. They're ordering food on screens, and no one's cleaning them in between. And that was a Sunday. And I thought, it's illegal to go to church and sit 6 feet away from the next family and listen to a spiritual teaching, but this is allowed. It seems maddening. Now, you mentioned whether or not this is going to stick. So what exactly does that mean, and what is the JCCF looking at doing?
Well, they, of course, an amazingly helpful bunch of people, honestly. In any event, they are echoing my concerns, and of course it's very early. The judgment just came out yesterday, so everyone is kind of trying to digest it, and of course the clients, they're paramount in this thing. They have to decide what they wish to do, but we have the option to appeal this thing. We think the judge has given us some good stuff to work with here. There's some pretty clear grounds of appeal, we think. And we're going to consider that for a while and discuss things with the clients and make our decision, but that's certainly an option for us.
Well, that's promising. Now, one of the things that Justice did mention during the hearing was, the amount of evidence coming from like an epidemiologist or something like that. So if you appeal, would that be on an affidavit or anything like that?
No, what happens in an appeal is that we use... you probably heard the phrase record of the proceeding a few times in our last go-around down there. Well, the record of the proceeding in the Court of Appeal is all the evidence that was before Justice Hinkson. So that gets bound up into various appeal books, and then we file what's called a factum, which will set out our argument as to where we say the judge erred in his reasoning. And we're, like I say, at this juncture, we feel that we've found some fairly significant mistakes in his reasoning. Of course, that'll be for the Court of Appeal to decide, but and of course the clients will have to decide whether they want to pursue that process. But so that's what we're going through right now.
Recently, we've had some new taste of freedom dangled in front of us in British Columbia. People are now allowed to gather outdoors with up to 10 people, with, making sure they're practicing certain things. And I'm hearing or reading that Dr. Bonnie Henry is considering allowing churches and other places of worship to be able to do something outdoors. Do you have any more information on that?
Not really. I just know what you know through the media for the most part. And things change so frequently that it's really hard to stay on top of these things. I do note that since the freedom of to protest has now been recognized by the court, and there are no such limits on those, it'll become difficult to really enforce any kind of distinction between some kinds of gatherings outside and others. And the whole reason the freedom to protest has been recognized and protected by the court is because Dr. Henry herself conceded that there was simply no evidence at all of infection risks coming from those activities. So it's going to be difficult, I think, for the Crown to effectively enforce limits on some outdoor gatherings but not others, when the Crown itself has conceded there's no health or scientific basis for controlling those activities. I think it's when one goes to court, one hopes for some clarification on these things. I'm not sure the judgment has achieved that.
Can you break it down for us a little bit? What exactly was the evidence against the church that justified these infringements?
Well, one of the points we urged upon the court was that there was no evidence. And as we read through the reasons, it's quite clear that Justice Hingston relied on what Dr. Henry was saying were her reasons for taking the steps she did. And this is all very interesting. It may well establish that she acted in good faith and in her mind doing the right thing. But that's not evidence in support of the distinction she made. What was lacking from the evidence before the court, and what appears to be lacking the attention of the judge, is whether there's some cogent scientific basis for making the distinctions she did. There has to be some data from some reliable source focused on the specific activities at issue. And there simply isn't any. There's Dr. Henry's stated reasons to the public as to why she's doing what she's doing, but that's not, quote, cogent and persuasive evidence in support of the restrictions. That has to be produced by the Crown in a case like this, and it simply wasn't.
I think maybe God's saying it's time to get the gospel on the streets. That's the way I look at it. You know, maybe we've been cooped up in the building too long, but I want to thank you so much. Big win for protesting. My colleagues back east have done a lot of coverage on how protesters are being treated and arrested there, and even some of my colleagues have been assaulted while trying to cover these protests. So I wasn't sure if that was going to be in store for myself and my camera guy Matt here. So I'm glad to hear that we are able to do that here.
Well, I'm glad that you weren't assaulted in the context of this interview.
No, maybe if we get into this wine later, I don't know.
Good idea.
Thank you so much.
Thank you.
Well, we get to celebrate one big win for BC and Canada. In British Columbia, we can peacefully protest, but the battle is not over. If you haven't already heard of our initiative, it's called Fight the Fines. You can go to fightthefines.com and let us know if you've been fined or charged for any tyrannical reason since the declared pandemic. And you can also support other Canadians who have, as we provide them with free top-notch lawyers to fight their cases. That's at fightthefines.com, and we appreciate your support.